The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
A man on trial for murdering his wife says police turned his mistress against him. But does his defense make sense? And in New York, actors go head-to-head in the Blake Lively-Justin Baldoni saga. And we had the details from court today. Plus, a former Michigan powerhouse football coach back in court today facing those stalking charges. The court of law is done for the day, so let's call to order Court of Opinion. Welcome to Court of Opinion. I'm Jenaé, your moderator for the hour. Thank you for joining us for a discussion on the top cases that we are covering across the nation. First, we are taking you out to Virginia for the au pair affair murder trial for Brandon Banfield. He is a former IRS criminal investigator, and he's accused of masterminding an elaborate murder plot to kill his wife by luring a man he found on a fetish dating website to his house to take the fall for it all. From there, prosecutors say Banfield staged the scene to make it look like Joseph Ryan stabbed his wife and that Banfield then shot the man in self-defense. The family's au pair, who he was having an affair with, was also in on this plot, according to the prosecution. She's already testified against him in this trial, but now it is the defense case. So before we get to our panel and their opinions on this case, let's listen to day 2 of the defense case in the case against Brandon Banfield.
What I'm trying to determine over the lifetime of the case, was the catfishing theory ever disregarded or put to the side?
No. Was
there periods of time where the homicide squad was not supporting the catfish theory?
So everything is on the table. I wouldn't say that it wasn't. We explored all options, and that was always on the table.
And you charged Juliana Perez-Magalhaes in October of 2023, correct?
Yes.
So was it concluded at that point?
She was charged for her involvement in the crime. So she wasn't charged with Christine.
Right. And so was it based upon her recantation that Brandon Banfield was charged?
No.
Your investigation was focused on who killed Joseph Ryan and Christine Banfield, correct?
That's correct.
And you followed the evidence in your investigation, and that evidence led you to charging decisions, correct?
That's correct.
Okay. Juliana Perez-Magalhaes was charged because you were able to prove that she shot Joe Ryan. The evidence supported that, correct?
Correct.
Okay. And Mr. Banfield was charged when? What was the turning point in your recollection of when Mr. Banfield was charged?
When we got the blood evidence back.
So based on the evidence, I think that after I reviewed it, it was about a month in, I believe that it was overwhelming that this was a catfish. I think the term has been used kind of across the board now. That was set up by the defendant, yes.
Okay, and after doing 1 month's worth of work and as a lieutenant, you were able to arrive at that conclusion?
Well, I reviewed sort of the evidence that was provided to me by the digital forensics people. You know, for instance, the accounts were created in January. They had never, you know, they were brand new accounts. That was unusual to me. We reviewed Christine's history. I think it went back to the mid-2000s. She had never so much as visited a porn site that we could find, so I thought that was...
I guess my question was about the digital forensics.
Well, I think reviewing her digital footprint, there was no evidence of that.
In terms of catfishing, that was a theory that you were pushing, correct?
That I was...
Pushing.
It's what I believe the evidence overwhelmingly supported, yes.
What, if anything, did you do with the homicide detectives in order to convince them of your theory?
We reviewed the evidence many times between March and September. However, it wasn't until the co-defendant came into proffer that everybody was in agreement that the catfish was the actual correct
Okay,
theory.
so you arrived at the determination that you were right because Juliana Perez Magalhaes told the story.
Yeah, I think she filled in the blanks, but by and large, what she said was consistent with what I believe the evidence showed pretty much within my first 30 days of being involved in the case.
Cover up, cover up, cover up. That is where we see this defense going in terms of what they say happened here, that none of what the prosecution has in this case is correct, and that the au pair, that she lied about everything. Let's bring in our guest panel to see what they think about this defense. We have parent rights attorney David DeLugas with us, criminal defense attorney Franz Borghardt, and criminal defense and civil rights attorney Sue Ann Robinson. Great power panel to be here with us. Great to see you all. David, I'm going to start with you.
Great.
This defense, does it make sense to you that they are saying, no, this happened the way that it looked initially, where Brandon Banfield showed up, he saw somebody attacking his wife, he killed him, but that man had already killed his wife?
Well, look, the burden of proof matters a lot here. The burden is on the state to prove beyond a reasonable doubt that the crime occurred as they contend. The defense just needs to poke enough holes in it to get somebody on the jury to go along with the not guilty finding. By the way, not guilty doesn't mean innocent. It just means not proven beyond a reasonable doubt. Does it work? Well, in light of some of this evidence that has come to light, it wouldn't seem so at all.
Franz, I see your opinion brewing over there. Tell me if you think the hole picking is happening.
So as a criminal defense attorney, sometimes we're asked to paint the Sistine Chapel using factual crayons. And that's the box of crayons it looks like these guys are using to paint their theory and themes. I get it. I understand. You got the au pair that's taking her deal, rolling. I just don't. I kind of feel like this is the best they can do with these facts. And yeah, at least they're prosecuting a defense. That's something, right? They're trying to poke the holes. I just don't think that their boat's gonna stay afloat, because I think the only holes they have is in their case, and I think they're sinking pretty quickly.
Sue Ann Robinson, what's your opinion of this case? Because my estimation is, if they have to say that it went the way that the defendant initially said that it went, then not only is Juliana Magalhaes lying, but then Joseph Ryan is also a liar, because he went over that house to do a knife play where he said, I'm not going to cut too deep. But the allegation is from the defense that he actually killed Christine when he got there.
I think the defense is always going to have to defend, and that's what they're doing. They're taking what they have and they're putting it together to break down the prosecution's case, saying that the investigators had tunnel vision. That's not a very unique defense, but it's one that's tried and true. They're looking at the detective on cross-examination and saying, oh, this is the theory that you were pushing. You had to convince all the rest of the officers and investigators to go along with your theory. So they're saying, hey, this is an investigator that's overzealous and had tunnel vision about this catfishing theory, as opposed to referring to the facts as they've come out, as far as the investigators concerned, as what they are. This is what the digital evidence shows. So the defense is defending. They're doing what they have to do with what they have.
Oh yeah, I'm glad you mentioned the tunnel vision, because that is definitely what we're understanding the defense theory is here. How do you think jurors take the tunnel vision argument, that police were going to a person rather than following the evidence?
Of course, it's the argument that the defense is always going to make. Jurors, they're a wild card. They come from every walk of life. They have different thoughts. They watch a lot of TV. They watch this channel. And they're more savvy today than I think they were years ago. I do think that they're always looking for the, no pun intended, killer piece of evidence, because CSI, what do we have? What ties them together? But yes, it makes sense. The digital footprint, as we just heard the testimony from the detective, does show that the decedent, his wife, had no prior porn fetish site visits. that would tend to show that this was in fact a false website or profile set up by him, according to the au pair at least, or maybe the au pair did it and he didn't do it. So that might be one, what do you think of one defense is, let's blame it on the au pair. She did the whole thing. It was catfishing, but she did it.
So on the one hand, you would expect someone who is putting their big toe in the water for the first time to do this kind of tryst wouldn't have a large-scale digital, map of constant getting on and trying to find people. In the same breath, you would expect a digital footprint. So I don't dislike the defense. I just think it's problematic. But I will say, my experience is jurors don't want to believe, unless confronted with serious evidence, they don't want to believe that cops are intentionally trying to railroad somebody. It's much better to have that tunnel vision argument because maybe they just got it wrong. And we're all people, and we get things wrong. That's an easier pill for jurors to swallow if they're trying to get to reasonable doubt as a defense. This is not a great case for the defense.
Okay, I want to throw another piece to the puzzle because they really had a pretty interesting witness yesterday who says that he found through the digital forensics, and he's someone who worked for the government, that Christine's Gmail account was definitely the one who did this, and that it would have been hard for someone on a different computer to actually do that. And then they had this person on the stand today. This is David Giaccio, and he talked about the pushback he got on this case when things were seeming to turn away from the catfishing theory.
My job was to be the homicide supervisor. Also, I was asked to review this case and other open cases.
And were you told to close this case?
Well, of course, that's the goal for any open case.
Specifically this case?
Yes.
Okay. Were you told to clean house in homicide?
If necessary. I think I told all of them when I first got there that that was not my goal. I hope to keep everybody who was there.
And did people leave?
Yes.
Okay. And how many people left the homicide squad?
During my time there, 5 were promoted to sergeant. I think they're all back in the Major Crimes Bureau now, and 1 was transferred out.
All right, Franz, I saw you reacting to the clean house comment and keeping in mind that the witness that I mentioned who said, I don't know if this vet life was outside of Christine's understanding, he's one of the ones who is no longer in that department.
So that would certainly be the linchpin I would try to leverage if I was a defense attorney. If I'm a juror, I'm thinking, does my spouse, does my partner have access to my email? Do they have my passwords? And sometimes the answer is going to be yes. Sometimes the answer is going to be no. But you better believe that's going to be talked about in the jury room. So it's a good leverage. It's a good lever for a defense. You've got that agent who's been trained on how to do police activities, and the counter is going to be in closing. Look, this guy knew what he was doing. He planned it. He was methodical, and he had the tools and the training to do it. It just didn't work.
All right, David, I want to get your opinion on this that happened in court today. So the defense asked for the jurors to read the 71 letters that the au pair sent to the defendant in this case during the time that she was in jail, but he wasn't. There was actually 10 months after she was arrested before he was arrested. So take a look at some of what we pulled from these letters. She read a few of them on the stand during her, when she was actually speaking on the stand. Now, she said, I'll never forget how much I love you more than anything. I miss you every single day. You mean everything to me. I love you with all of my heart, and I always will. And even until my last breath, love you, all of that. That's a pretty early on one. Let's go to one that's a little bit later, and this one having to do with the marital bedroom. So the defense doesn't deny this affair, and she's letting him know that she was asked how we got together and moved into your bedroom, so meaning the marital bedroom that she would have been in a different one during the time that Christine was alive. And then she says, we moved into it after what happened, meaning this incident. We talked about it, it wasn't hard, and since we had a type of relationship before, we enjoyed each other. This is what she's putting in some of these letters, but the defense, David, not shying away from these jurors taking the time, not in the deliberation room, but they're inside of the courtroom to read them.
Well, it makes sense. If you're the defense, you want to paint the au pair as the person who created the event, who maybe did it on her own. He's just the victim of her obsession with him. It would only make sense. You have to come up with some story if you're on the defense side. The flip, of course, is if she has counsel, she knows those letters are being intercepted, they're being copied. It's not going to escape scrutiny because communications between somebody in jail and on the outside, unless it's attorney-client privileged, it's going to be scrutinized. So maybe she's setting up her defense and trying to reel in that plea deal that she wants to get herself out of jail because that's not a pleasant place for anybody to be. Not that I've spent any time
That's a unique take on it. We've got to leave it there. Everything is going to start up again tomorrow. They're hoping to get things done really quickly before that winter storm comes in there in Virginia. But up next, we're going to turn our attention to New Jersey, the Mansion murders trial, where evidence was presented in court today showing weapons potentially used in the deaths of Keith Caneiro and his family. We have more coming up next.
The Court TV podcast will return.
In New Jersey, day 7 of testimony has wrapped up for the Mansion murder trial. Prosecutors say that Paul Caneiro killed his brother-in-law, his sister-in-law, and brother and sister-in-law, and then fatally stabbed his niece and nephew. This all back in November of 2018. They also say he set the house on fire, and then in an attempt to conceal the crime, he lit his own house on fire to create this illusion that there was an attack against the brothers. And that's the defense, that someone else did this horrific crime. Now, jurors took in hours of evidence today, so we're highlighting the moments that mattered most. Here's what our team found as the most compelling evidence of the day, starting with a gun belonging to Paul Caneiro shown in court. The 9mm handgun was found under Paul's bed, along with 2 holsters. Now, images of Paul's gun safe were also shown. It contains many firearms and ammunition. A 9mm bullet casing was found outside of Keith's home. Let's bring back in our guests, see what their opinion is of this evidence. We have David DeLucas, Franz Borghardt, and Sue Ann Robinson. Franz, I'm going to start with you on this one. When you're showing weapons to people, whether or not they were used in the crime, you're showing that the defendant had weapons in an arsenal. What do you think that says to the jury?
So the weapon itself is not the problem. Does the casing, the spent casing, match the weapon? Because if it doesn't match the weapon, I mean, anybody that owns a gun is not responsible for this crime. And in fact, coincidentally, if it's the same caliber, it's not necessarily strong evidence. If there's a casing, if it's spent, they can test it. They can test the firearm. So I don't know how, the fact that he owned a firearm, I don't know that that's going to get them to the finish line as a state prosecution, but maybe there's another firearm somewhere. Who knows? But I don't know. I just don't think it's strong.
I'm going to add some facts to that for you, Sue Ann. So they do say that the casings at the crime scene and the casings or the bullets found inside of Paul Caneiro's home, there's a similar stamping on them. So there may be a match. We've got some more witnesses we haven't heard from. DNA expert hasn't testified. Medical examiner hasn't testified. What's your opinion of the evidence?
I think when you show the jury an arsenal in a quadruple homicide with a double arson, they're starting to think, okay, there's a possibility that this event could have really happened because this person has a safe with weapons. That could start to play in the jury's mind that, hey, such a violent, heinous crime could be committed by someone that has this cadre of weapons in their home.
So, David, do you think the defense then has to explain that away, explain perhaps why he has these weapons? He even has a lot of target sheets to show he's been doing some target practice, but that's not necessarily uncommon.
No, in fact, what I'd like to bring out is this. During jury selection, the defense knows the evidence that the state's going to bring forth. So if the defense team did their job right, they have people on the jury who themselves own guns, who have gun safes, who target practice. So it's meaningless. In fact, it may sway the jury the other way and go, why are you contending that just somebody owns guns and they would commit this crime? Show me something more. This is way insufficient.
We got ways to go in this one. Let's look at another piece of evidence shown today. This was a big one considering what happened to victims in this case. Now, this is a knife that was found in the backpack of Caneiro in his wife's car. And witnesses the witness on the stand, who was a crime scene investigator, so not an expert on blood or DNA, but he said there was no blood seen on it or fingerprints. But keep in mind, in this case, Paul's niece and nephew were stabbed to death. So no doubt, Franz, this was jarring for the jury, even if they don't have the connecting evidence yet.
So again, the mere presence of a knife. I know this sounds so defense attorney of me, but the mere presence of a knife, does it mean that it was the knife? And I tell you, without DNA evidence, without some kind of forensic link, you know, there's going to be wiggle room for the defense. I'm not saying it's not going to be persuasive to the jury, but the mere presence just isn't enough for me. I need more. I need that next step.
Sue Ann, your opinion?
I think that is very defense attorney of you, and I think I agree. If I was the defense and I was defending, I would say this with nothing more is not enough. But we have to get into the minds of the jury, and we hope the defense attorney did a good job in jury selection, but we don't know. But I definitely think that seeing these weapons is gonna have an effect on the jury. You just have to be realistic. It's a very heinous crime, and there is a stabbing involved. So seeing a knife, seeing guns, that's going to affect the jury for sure. Will it be enough for the prosecution to get them over the finish line? Not at this point, but I definitely think it's jarring, for sure.
They've got to be thinking about those kids when they see that knife.
No question. A knife, as often spoken about, shows it was up close and personal. That actually plays for the defense because it's his niece and nephew. The knife with no DNA, not yet, seems improbable. If the defense likely will call an expert witness who says, how do you eliminate all DNA from a knife if it was used in the attack? And the answer is likely to be, it's almost impossible.
Real quick follow-up, Franz. If we do find that this was just a knife found, because there were a lot of weapons shown, so we can anticipate not all these weapons were used, does that turn the jury off in any way towards the prosecution if they brought in a knife, showed it, but then ultimately no knife was recovered?
In the world of prosecution, if you're building your case, you have to line up the dominoes. So, assuming they have nothing else, it might turn them off. But I suspect they have something else. And if they have something else, well then, the accumulation of circumstantial evidence can get them to that finish line.
Speaking of something else, let's look at our third piece of evidence. And these are jeans found in the basement of Paul Caneiro with blood stains. And according to the opening statement by the prosecution, again, we haven't heard the DNA expert in this case yet, but these jeans had DNA from Caneiro's niece and nephew on them. And there was a lot of fire damage. You could see it there to these jeans because it was in the basement, and in the basement is where that fire started. The prosecutors say Paul Caneiro set himself. Sue Ann Robinson, your thoughts on that image?
These are the smoking pants. You know, this is a piece of evidence that has DNA of two of the victims of the crime, and in a double arson, it has evidence of being burnt. So it's one of those pieces of evidence that the defense is going to have to go very carefully when explaining either why it's there or explaining that it doesn't have anything to do with their client. But definitely some burnt pants with two sets of DNA from the victims is a very, very, very good piece of evidence for the prosecution.
Oh yeah, a lot of good evidence coming out now, but we're eventually going to be turning to the defense case once they wrap, but I am very much waiting to hear from the medical examiner and the DNA expert in this case. We have to leave it there, but coming up next, we're going beyond the gavel. We're breaking down the biggest true crime cases, and this one has a lot of people talking, and it's been a while that people have been talking about it. These two co-stars turned courtroom battle opponents. The film that was the film set rather that sparked the federal fight. And what's next in the case? We have that for you on the other side. Stay with us.
Now, back to the Court TV podcast.
As hard as this choice is, we break the pattern. Or the pattern breaks us.
We're taking you now beyond the gavel for a case that began on a film set and ended up in a federal courtroom. A federal judge is considering actor and director Justin Baldoni's request to dismiss a lawsuit that was filed against him by his It Ends With Us co-star Blake Lively. It all began with their 2024 movie, It Ends With Us. She accuses him of sexual harassment, creating a hostile work environment, and orchestrating a smear campaign against her. Those are the allegations. Court TV field reporter Cody Thomas has more on the case of the feuding stars.
We all have an idea of what life can be.
I want to see you again.
It Ends With Us is a story of romance and domestic violence, but the legal battles between the film stars have taken center stage. Blake Lively, wife of A-lister Ryan Reynolds, is Lily Bloom, a florist. Lively's big break came in 2005's Sisterhood of the Traveling Pants and Gossip Girl 2 years later.
Oh, that's my brother Ryle.
The first official customer?
Justin Baldoni, who owns the rights to It Ends With Us, produced and stars as Ryle Kincaid, Bloom's love interest. Lively filed a lawsuit in December 2024 accusing Baldoni of sexual harassment and attacking her reputation. Among her claims, Lively accuses Baldoni of repeatedly adding sex scenes focused on her and casting Baldoni's friend in a delivery room scene so he could see Lively unclothed. Then Baldoni filed his own claim, seeking $400 million from Lively and her husband, saying they falsified claims to take control of the movie and engaged in an orchestrated public attack on his reputation. His lawsuit also alleged that Lively ignored his request for her to meet with an intimacy coach before filming certain scenes. A judge dismissed Baldoni's claims in June 2025, but Lively's case is still active in New York federal court. She's seeking unspecified damages.
Now, here's where we are now. Today, this happened. 3 motions were argued. A motion for judgment on the pleadings, a motion for summary judgment, and Lively's motion for spoliation sanctions. A judge is going to be issuing a ruling on these at a later date. Blake Lively's spokesperson spoke to the press outside of that federal courthouse today following the oral arguments, saying Lively wants her day in court.
Blake Lively wants this to go to trial. She really is in a position where she's got mountains of strong evidence. She feels very good about her claims, and she wants to send a message to all women that if you are wronged and harmed in the workplace, you can stand up for yourself. You can say that this is not right and should not continue.
And so that's what happened today. And we got to get reaction from our power panel on where we are in this saga that has been going on for quite some time. David DeLucas is with us, Franz Borchardt, and Sue Ann Robinson. I want to lay out things for people because this can almost get convoluted, I believe, with everything that's been going back and forth between these two. But we know this is about a hostile work environment that Blake Lively says was created on the set. And there are some very detailed things that she lays out. There's dozens. But Sue Ann, I'm going to start with you on this one. And I know people may not know when they watch you here on Court TV that you also have acting in your background. So I want to get your perspective on some of these claims that Lively has. She said because this is an intimate scenes, there were intimate scenes here, that they should have hired an intimacy coordinator, that there were times that he ad-libbed on those intimate scenes and didn't get her consent, talking about Justin Baldoni, who's also her co-star. What do you think about that in terms of what you know about the industry?
I think the bottom line is what was the environment that was created, and of course, what is the evidence? Is there going to be testimony or evidence that the environment was charged, that it was targeted towards her? Are there going to be other people that are going to be able to testify that, yes, she was being objectified? I know in his case, he mentioned that he had an intimacy coach, but that she refused to go there. So to deal with the intimacy coach or to sit down to have the actual coaching sessions. So it's going to be one of those things where it's going to come down to what the evidence is, what the witnesses say. If there's an intimacy coach that's on set that's saying, hey, Blake Lively refused me, then that totally devastates that part of her case. If there isn't one, and that wasn't in fact actually made available to her, and that is something that should be present on the set, then that's a big problem for his case.
Franz, the defense here in filing their motion to dismiss, they said these are petty grievances, they are trivial, and I think that's what they'll have to prove in order to survive a motion to dismiss or motion for summary judgment.
I think her problem is in the pantheon of sexual assault and sexual harassment cases in Hollywood that we've seen over the years, and especially recently. Hers, I'm not saying it's not factual, hers seem kind of light, especially in light of the creative nature of movies. Like, if she is found not to have participated with an intimacy coach, I think that hugely hurts her case. These allegations of, oh, he had too many sex scenes, and we only had this scene so he could see me. I could see a juror saying, you know what, I don't think that that's sexual harassment. You know, and candidly, kind of some of the celebrity behavior amongst these two makes her less sympathetic as an individual, and jurors want to rally behind people they want to rule in the favor of, and if they don't think that someone's a sympathetic true victim, they're not going to rule in their favor.
One of the most shocking ones in terms of the allegations to me was that she says he hired a friend to play a doctor in a childbirth scene where she was topless, rather than having a professional actor there. David, what's your opinion of this case? I know you have some film background, that you're working on a film that hasn't come out yet, Ambulance Chaser, so not connected to this case at all, but what's your opinion of this one?
First thing, I doubt that his lawyers used terms like petty in their pleadings. I would hope they did not, because any allegation should be taken seriously. Ultimately, the word you used is on target. It's a matter of consent. It's a matter of permission. Well, before a scene is filmed, there's a script, there's a screenplay, there is ad-libbing all the time. He was a producer. That doesn't give him a license to do whatever he wants. Who was the director? If he was the director, what did the director do? When there are intimate scenes, there are closed sets. The actors in those scenes often dictate who's allowed to see, what they're allowed to see. So there's advance notice. If he hired his friend and she's complaining, she knew about it before the scene was filmed or shot. So the issue to me is a matter of consent and permission. Clearly, if she did not consent, she has a much stronger case. The question is whether, given the way productions are done, did she not know this ahead of time and have the opportunity to say, hold on, I'm not doing this scene?
Yeah, she's certainly denying a lot of consent. Sue Ann, what do you think about what David just said?
I hear you, David, but even if she's aware of what the scenes are and what's happening beforehand, she's also under contract in certain regard to get the film done. So I think it does go to her work environment, because even if this is what the script says and even if she knows who's going to be on set, now when she's in the actual environment, it's how everything put together is making her feel. If she does feel like she's being targeted, if she does feel like things are being ad-libbed to make her uncomfortable or put her in a hostile environment. So I think everything could look fine on paper in terms of the script and who's going to be present. But then when you're actually in the scene, acting in the scene, it could be a different environment physically.
Franz, final word on this. I know you heard something in the arguments or in that motion for summary judgment that surprised you from the defense's side, their take on it. But either comment on that or where you think this goes. What is the judge going to do with this motion for summary judgment?
I think this goes to trial. The fact that we're discussing these factual issues probably means that the motion for summary judgment is going to be denied and it's going to go forward. I think Blake Lively is either going to be a hero for actresses and actors, or she's going to set them back. And it's going to be very factually specific, and if it's shown through evidence on the stand, testimony, documents, if it's shown that she was blowing something out of proportion that really didn't happen the way she said it did, it's really going to hurt true sexual harassment and sexual assault victims.
And that is why so many people are on two sides of this story. They either support Blake Lively and say she is part of the Me Too movement, or they say that they support Justin Baldoni, saying that she is using it in a fraudulent way. Let's get to our break. When we come back, hot takes, cold facts. Our panel is going to be giving us their opinions on today's biggest headlines, including two very different verdicts reached and the reactions from both of those, plus a fired football coach back in court for his stalking case. That's next.
This is the Court TV Podcast.
Welcome back to Court of Opinion. We're about to get the cold hard facts and the hot takes from our power panel, where they give us their wildest opinions on some of the biggest headlines. And we're going to get to the first story that grabbed so many headlines yesterday. A huge verdict. The jury acquitting a former school resource officer who was charged in connection with the Uvalde school shootings. And he was acquitted on all charges. This is former officer Adrian Gonzalez. He was facing down 29 counts of child endangerment after 19 children and 2 teachers were killed in that massacre at Robb Elementary School in 2022. Now, Gonzalez and a former school police chief, Pete Arredondo, they were the only 2 who were indicted in this case by a grand jury. And this happened back in June of 2024, so there was some time before these indictments came down. They are the only 2 people indicted, and for Pete Arredondo, his pending trial still hangs in the balance. Let's bring in our guests to see what they think about this one. We give them 25 seconds so we can get to all of the cases and get to all of them. Our guest, David DeLucas, Franz Borghardt in studio, and Sue Ann Robinson out in Florida. I'm going to start with you, David. Your reaction to the acquittal of this school resource officer.
I want to read the jury instructions. I want to know what the jury was told they can and cannot do based on the evidence. But here's something most people don't know. There are federal cases that say police officers do not have an affirmative duty to help. If they shoot you and you're bleeding, they do not have a duty to render aid. That needs to change. We need to change the law through legislation that says police officers in certain situations have an affirmative duty to help or to take action.
Until then, be a big change.
And it's not going to happen because of the lobbying power they have.
Got to move to Franz Borghardt. Your reaction to this, especially in light of the fact that this is the second school resource officer to be acquitted in a school shooting.
Second high-profile acquittal. I think that what we're seeing is jurors saying, hey, you want to go sue the heck out of these people and their agencies? Sue them. We're not going to criminalize it. And in the back of my mind, I'm also thinking, who in the world's going to want to be a police officer? If this is the life you're going to live, is you can go to work and be in danger of somebody killing you, a shooter, or if you don't act and you don't do certain things, you can be prosecuted for up to 29 counts of crime.
Sue Ann Robinson, you are there in the area where the Parkland school shooting happened, where that other school resource officer was acquitted. Do you see anything different happening after this? And do you think that prosecutors continue to go after the police chief in this case?
I just want to say one name, Scott Peterson. I am from Florida, so I was here for all the nitty-gritty of that case, and I watched it from start to finish. So this verdict absolutely does not surprise me as a Floridian that watched that case, and it doesn't surprise me as a civil rights attorney. Police accountability is a very hard-fought thing. So the fact that he was acquitted does not surprise me at all.
All right. We will continue to follow whether or not the police chief is going to continue to face charges and when his trial date is actually going to be set. Let's move to our second story. This one out of Ohio, days after an elderly man was convicted of murdering an Uber driver who was sent to his house by scammers demanding money. Letters have begun pouring into the courthouse begging the judge in that case to show him leniency at sentencing. William Brock was convicted of felony murder and kidnapping for fatally shooting Lolita Hall outside of his home. And more than 80 letters were submitted to the judge, one being from his grandson, the one that scammers used to claim that he was kidnapped to try and scam this elderly gentleman. Now, he says, the grandson rather says that he feels guilty for not calling his grandfather back sooner because he was called that day to see if it was a scam and he didn't respond to the call. Franz, let me start with you on this one. Your reaction to all those letters coming in and if you think it's going to do a difference.
So this is going to be unpopular. I think you got to put him in jail. I think you got to put him in jail, and unfortunately, he's going to die in jail. Sad, tragic case. He certainly had a defense, but the reality is none of his defenses rose to the level under the law that he gets a pass. And unfortunately, his age doesn't give him a pass. So I know it's going to be unpopular of me to say this, but I think he has to go to jail, and I think he's going to die in jail.
Sue Ann Robinson, your take.
A tough case, agreed. He's an elderly person. It reminds me of the case in the movie theater where the guy pled self-defense for killing the person who threatened him inside the movie theater. It reminds me of that. I think his defense did a great job of showing how his medical condition and his age kind of played into why he was so threatened and into his self-defense claim. I feel like his lawyers needed to do better in this case because it definitely could be self-defense.
David DeLucas, final take on this story.
I'm going to agree in part with both my colleagues. I think he goes to jail, but I think in the pre-sentencing phase, when the judge gets the report, given his age and given his frailty, given the conditions of prison, I don't see him going there for long. I'm not saying that's fair. I'm not saying it's right. I don't think anything about this case is good. But putting him in jail does the public, does us no good at all. Does it send a message? I don't think so.
All right, let's move to our final story of the day. This is out of Michigan. A lawyer for a fired University of Michigan football coach, Sharon Moore, he's seeking to have his home invasion and other charges against him, including stalking charges, dismissed. Authorities say that Sharon Moore entered a woman's apartment on December 10th and blamed her for him losing his job that day, and then grabbed butter knives and kitchen scissors and threatened to kill himself. He was fired for having a personal relationship with that woman who was a football staff member and for lying during the investigation. His lawyers told reporters he was arrested based on misleading statements and that without them, there would be no probable cause for these charges. The judge did not make a ruling today. Franz, let me start with you on this one. You saw in those pictures, his wife is there beside him. Important in a case where he's accused of cheating with that woman.
Judges are reluctant to usurp the power of juries. And it sounds like he may have some fantastic defenses. I don't know that this judge will dismiss based on lack of probable cause. I think this will ultimately need to be one that has to be tried to a jury, or ultimately the prosecuting entity will have to make a tough decision. But I just don't see a judge dismissing this.
David DeLucas, he's out on bond. Of course, he's already charged and booked, and we saw that mugshot, but quite the juxtaposition.
I think this is another one of those cases where we all know what the facts are. The only question is, did the police follow proper procedure, and therefore the evidence that they gathered, is it going to be permissible to present that to a jury? Is his arrest based on probable cause? And I would like to think that a judge will differentiate between justice, which means he's guilty probably, and the procedures that the police officers took or didn't take.
We will see how it plays out, because this is one where the court of public opinion has questions about whether or not this has more to do with football than meets the eye. But Sue Ann Robinson, let's get your take on this one, the final one of the hour.
Yeah, the bottom line is there has to be a substantial likelihood of conviction for the prosecution to bring this case. And they did. So now it's going to be up to the judge. Do I think the judge is going to step in there and say, and not give it to a jury and give them the opportunity to parse through the facts of this case? No. The optics of this case right now are good for the defense because, as you pointed out, Julia, his wife is standing by her man.
It's great for optics, no doubt. Our thanks to our power panel this hour, Sue Ann Robinson, Franz Borghardt, and David DeLucas. We appreciate your time. Thank you for connecting with us this hour. I'm Julia Jenaé for Court of Opinion, reminding you we all have opinions, but they should be rooted in facts, and we should be striving to respect the other's opinion even when we don't agree with it.
This podcast is a production of Court TV. Go to CourtTV.com for more content, trials on demand, and to find out how to watch Court TV in your area.